Tim Lessner with Lorenzi, Dodds & Gunnell. I'm the planner that worked on this project, and obviously I was here a couple weeks ago. I had submitted to you a letter that I believe addressed most of the concerns that your board brought forth that evening. I would hope that that certainly did address your concerns. And other than that, I'm here to answer your questions if you have any. I fully support staff's recommendations and think that along with myself and my firm, staff has done a good job here also, as did the state reviewers that looked at the project also.
Mr. Lessner, it appears to me that there is some cemetery plots on the site, and they're going to be designated according to your letter dated August 27th, or memo dated August 27th, by a fence. Is that correct?
Yes. There is a cemetery that has been found near the rear of the property. It's been designated to be an open space. It was decided through mutual, I'll say, discussions after many, many reviews with staff and the archaeologist who did the work, that the best way to preserve and protect that property was to actually put a fence around the back of those lots and along the right side of that lot. There's a easement, an access easement that will be provided along the fence line for anybody who would want to visit the site. And as far as the, I'll say, the designation of the cemetery, we have a little detail of a proposed sign that would be constructed and placed in a specific area which is designated on the plan for information about that cemetery. And also there'll be language in the HOA documents to preserve it and protect it. And of course, as you well know, a cemetery is not necessarily open for everyone. It would hopefully just be used for the people or family heirs or concerned folks that would want to visit it.
Thank you.
Yep.
Any other questions for staff or Mr. Lessner? Yes, Nancy.
Two questions. Would it be fair to say that in this project, the conventional and cluster design combination of this project maximizes the number of buildable lots and minimizes the amount of open space?
I believe the density, this project is 105 plus acres, which would theoretically divide by 3 because it's AC zoning, agricultural conservation zoning. The property could theoretically yield 35 lots, and you could round that up and probably get 36 because it's 35.6 or something like that. So no, the answer to your question is that we have not maximized the density on the property.
Well, but not a lot of that property that is open space wouldn't be able to perk. The chances of being able to get the density. Actually,
there are additional perks on this property. For instance, I believe, I'm going by memory, I don't have the plan in front of me here, but in working with staff and trying to work with open space and buffer yards and proper recreational planning, there is at least one more perk on the property that we did not utilize. And if you look on the plan, I believe there's perks on the left front corner. They're up close to the road that originally we had another lot on there, another 1 acre lot. And working with staff, this term wasn't even brought up yet, I believe, or not tonight anyway, but Adams Willett Road is considered a scenic and historic road also. So in an effort to preserve I'll say the natural vegetation as much as possible across the front, we put a 75-foot buffer yard across the road frontage. So according to the subregs, section 75, we have to do a certain amount of road upgrade across the front. In working with that, we will be replanting any trees that are removed in that 75-foot buffer yard. But to make that all happen, we actually lost a lot up there. So I've already taken one off. And there were miscellaneous perks throughout the property that I probably could have utilized, but we chose not to. We chose to use the 33.
And my next question, and it goes to the zoning ordinance. The zoning ordinance says that cluster developments shall satisfy the following objectives. And there are 9 objectives. The 9th, which says cluster development shall further the goals, objectives, and strategies of the Charles County Comprehensive Plan. Now, I have a lot of the plan's goals and objectives in front of me. We all worked on that plan. I don't see a single one that this project will further. So can you enlighten me?
Well, I would respectfully disagree. I would venture to say that even in the staff report, they touch on the comprehensive plan and how this project has, in fact, met the goals and objectives of the comprehensive plan. There's several statements in the staff report in that regard.
Well, I believe those are talking about the number of houses inside and outside of the development district.
Well, if there's one specific issue or question you have, or a specific chapter about the comp plan, I mean, perhaps I could give you an example of each of the chapters that this project meets the goals, if there's something in particular that you have a question on.
Well, in the AC chapter, the description of AC, this property is AC, the zone provides for a full range of agriculture and farming activities and protects these establishments from encroachment. So that's the definition of AC. So we're not protecting it from encroachment.
The AC zone, for at least since the 1992 zoning, is a 3-acre zoning. 3-acre lots or cluster lots with that density is what that AC zone provides and allows.
Right, but the policies of the comp plan that was just approved and is in effect is the zone provides, is to protect for agriculture and farming activities and protect from encroachment. So that's the goal.
Okay.
And another goal in Chapter 3, page 2, is to protect the county's natural resources.
Well, this project is clearly, as we've discussed, under the old comp plan, which is why we're here tonight.
Except the zoning ordinance does not say that. Does not say which comp plan. It says the cluster developments, allow cluster developments shall satisfy the following objectives. And it's further the strategies of the Charles County Comprehensive Plan. That plan has been approved. The commissioners voted it into existence. And you're coming to us before us under this comp plan that we just voted for.
I suppose I should defer to staff on that issue. This application was clearly submitted prior to the adoption of the new ordinance, and it should be reviewed under that's why we did it. We submitted it under to be grandfathered from the Sustainable Growth Act, and we were forced to submit it in a timely manner, and we're in the process of meeting all the deadlines.
Well, you're grandfathered from the Sustainable Growth Act, but I would argue you're not grandfathered from the Comprehensive Plan. Another problem is that...
Mr. Ball's opinion on that?
I'm going to defer to our legal counsel,
Okay.
if I could.
Let me, start on this just in the general sense of what a comprehensive plan is versus a zoning code and subdivision regs, and that we all recognize that the Planning Commission had recommended a comprehensive plan, and the commissioners had very recently adopted it. It has some very far-reaching policy objectives in it that we have every intention, as fast as we can, to move towards implementing them. The reality, though, is the comprehensive plan is a policy document. It is not a zoning code or subdivision regs in itself. We don't use it as an ordinance. So a comprehensive plan is a very different animal than zoning code and subdivision regulations. As you know, and we will be coming back to you with what we're calling a 5-year work program fairly soon. But we have a task. One of the most important ones in the comprehensive plan is to overhaul our zoning and subdivision regulations. And as a part of that, we will go through some form of comprehensive rezoning. Staff's perspective is that is the proper place and time to get at regulating components or implementing ordinances. I also believe, I'm going to check with staff who reviewed this project, but we did look at this project from both the old comprehensive plan and the new comprehensive plan in terms of some of the items that Ms. Schertler is talking about. Is that correct? And I think we'd be prepared to address those if the Planning Commission was so inclined. It's a component of our staff report. The key thing here is trying to use the comprehensive plan as a set of laws, which it is not, to regulate development, individual development projects.
But forgive me for saying I'm not. I'm actually using the zoning ordinance. The zoning ordinance says that cluster development shall satisfy the following objectives, and one of the objectives is further the goals and objectives of this comprehensive plan. But it's the zoning ordinance that I'm looking at, not the comprehensive plan.
Well,
I mean, I'm looking at the comprehensive plan because we're clearly not following
You're
it.
using the subdivision code to get at the comprehensive plan. You're trying to tie them together, which I understand, but I'm also going to say that in our staff reports, we've looked at that as well. That's been in many of your staff reports that relate to these rural subdivisions. We've been doing this for some time.
So we're saying that this project furthers the goal of, this project is in the priority preservation area. And the goal is to protect and preserve 80% of the remaining undeveloped lands within the designated PPA. So you're saying that, I missed that in our staff report, that the project actually furthers that goal?
You can't use policy objectives in a comprehensive plan and try and get at those through an individual project at a time. What we will need to do is amend our zoning and subdivision codes to see that policy objective is implementable. That isn't in a current zoning code at this point. But if I could, we're getting at how the staff looked at this in relation to the new comprehensive plan. Heather, would you be comfortable with talking about that a little bit? Because I think it gets at your question.
Okay, I'm just going to take a moment here to formulate my thoughts to be sure I don't really speak out of turn. All of the staff reports that have gone to the Planning Commission for at least a couple of years now have included an evaluation based on information that was in the previous comprehensive plan and that's in the current comprehensive plan. And it doesn't necessarily speak to the issues that you're raising, Ms. Schertler, that they're more, like you said, dwelling unit type and development inside and outside the development district, because we did have some direction from previous Planning Commission members who were interested in that type of information. But since I've been preparing these reports for about 10 years now, we've never given a specific finding. There was a very brief period where that was considered, and there were discussions with the county attorney's office at the time, and it just wasn't deemed appropriate for the types of reports that we were preparing. So basically, the staff has stuck to the evaluation of the growth rate that's stated in the comprehensive plan, and that changed between the 2006 and the 2016. So I wanted to at least incorporate that because that's information that we've been providing for informational purposes, not necessarily requesting a particular finding or citing any type of regulation or basis for a decision on that information. It was simply to have it, documented. In terms of some of the other items in the comprehensive plan that Mr. Kai-Ziegler has talked about addressing in the future with rezonings, as far as I know, and please correct me if I'm wrong, I wasn't aware of a particular density change for this area in terms of the agricultural conservation zoning. That would be the main issue that we would be evaluating.
And there may not be on specifics. What I'm trying to get at is trying to use a comprehensive plan as a regulating tool isn't a good place to go from our perspective, my perspective. That we know there are a number of new policy objectives in the comprehensive plan that we need to move forward with and move those policy objectives into a new zoning code and rewrite. Some of that will involve changing the zoning of property in the future, probably. But we're not there yet. And that's a process that takes anywhere from 18 months to 2 years to complete. In the meantime, the question I guess I would ask is, do we intend to use the comprehensive plan to evaluate all projects that might be before this board or that we would be looking at administratively? One example would be, I believe that in the future, the idea is that overall development, we have, I guess we call it the 85-10-5 rule. Does that mean that every rural subdivision that comes forward has to have a mix of dwelling types as called for in the comprehensive plan? Or is that a policy objective that is looked at more globally? Because otherwise, in a rural subdivision, we would have the situation where we would have townhomes and condos and apartments. And I don't think that's a proper fit in this type of development application. I'm giving you one example that I can just kind of pull out quickly. That is a policy objective in the plan, but we can't apply that to an individual project. It's something that you look at more globally. Presently, we don't have any tools or mechanism to require that through the development review process. We know that we probably need to create them as a part of a rewrite of the zoning code, but it's not here yet. And so that, to me, is part of the, if you want to say, the risk or concern about trying to use the comprehensive plan as a regulating tool.
My point here is that this is, I'm referring to the zoning ordinance. The zoning ordinance says you shall, for cluster development, you shall further the goals of the comp plan. Cluster development, this project by right can do 1 house to 3 acres under conventional development. It's my contention that this project, the cluster design has to be superior. In my opinion, this cluster design is not superior to what could happen conventionally. And a lot of that has to do with the number of lots that can perk. And cluster development is supposed to be superior to conventional. And this is one of the things that makes cluster superior. In our zoning ordinance, one of the things that makes it superior is to further the visions and goals of the comp plan. So I'm not, even the old comp plan, what goals and objectives does this development further?
I think one of the simple ones that it brings forward is a cluster provision is the only way that you get at creating deed-restricted open space. If they are conventional, you have larger lots.
Yeah.
And in theory, on each of those lots, there is more development that happens, more impervious coverage, and the entire property is taken up by all the conventional lots. In theory, with the cluster provision, you're not gaining or losing any lots as a result of the way our system works, but you are getting a fair amount of deed-restricted open space that is preserved forever and a day.
Yes, but it's also private open space, which is not that much different, really, than conventional. I mean, it's, and could all of this property, could you get the density? We don't know. We haven't been able to do the perk tests on the whole thing to see if you could actually have get the density and the forest conservation easements that are required out of the property.
If I can ask a question, because I've heard that they have been done, and you're saying they haven't. So, I mean,
because right now the lots are 1 acre lots. So if you look at the drawings and you take those 3 lots are now 1 because they have to be a minimum of 3 acres.
Right.
And then you also have to get your roads and other services through there. Yes, the math is you get 1 to 3 for the whole subdivision, but in reality, you're not going to be able to get that density. And
why?
Because of the roads. You can't get the lots all have to be a minimum of 3 acres.
Okay. I mean, I thought the roads were included when you do the calculation. I mean, they were excluded from the calculation of the total available for the 1 acre lots on the 3 acre cluster.
No, my argument.
That's incorrect. But
no.
Mr. Leshman.
Yeah, I mean,
If I may, I think I see what you're getting at. You brought that up the last time around also, and I gave you several examples, many examples of projects that my firm alone has worked on over the last 10 years, which I believe are excellent examples of where we mixed 1 acres and 3 acre lots. Those subdivisions are built. They're beautiful neighborhoods. They're very desirable neighborhoods in all parts of the county. To answer your specific question, when we perked the property, when we started on this development 2.5 years ago, 3 years ago, we went into it with the idea that it was going to be a mix because we like to give a wide variety of home sites to folks, if at all physically possible. That's why we did it. So, that question, if the planning department, if the planning commission forbade that years ago, 10 years ago, 15 years ago, I would have never laid the project out like this. I would have done all 3 acre lots or all 1 acre lots. But since we've done many, in my opinion, very successful, wonderful neighborhoods that have worked very well over the years, it made sense to me to do exactly what we did here. You get the best of all worlds. If this was just a 3 acre lot neighborhood, there would be no open space. There would be no recreational trails. There would be, many of the aspects that we've given here, the attributes to this neighborhood, would not exist because you wouldn't have the opportunity to ask the questions that you're asking. So, could we fit 33 3 acre lots? I think I could, but we would have to cross streams. We would have many lots with resource protection zones coming right up to the backs of them. There would be wetland impacts. There would be resource protection impacts. The cemetery would be on the back of a lot. I mean, these are things that have been done in previous neighborhoods. We chose not to do that here because we wanted to protect the environment. We wanted to work with DNR and the state regulatory agencies to give them the largest buffers possible. I gave another close to 10 acres of forest conservation above and beyond what's required to help answer that question. So we've done everything that I believe we can to protect the environment on this piece of property. Your specific question, no, I did not want to even cross the stream back there with a backhoe to dig perk tests in the back, across those streams. So we did the best we could to save, protect, and enhance the environmental features of the property. So, I don't really have the answer to that question. Will it perk for 33 3 acre lots? But I didn't even want to go there because it would have meant additional stream impacts and wetland impacts and resource protection impacts. So, we don't really know the answer to your question. And if that's the burden of proof that the Planning Commission is going to require from now on, can I get 33 3 acre lots versus 33 cluster lots or a mix? Then, please tell us. Please tell the design community and the development community, and we'll do that. We'll go punch holes all over a piece of property. I just did not see that would be a necessary act to perform because historically we've done many successful neighborhoods that meet this requirement. And as far as the perk test being done, yes, every one of these perks on every one of these lots has been performed, being monitored by the Charles County Health Department, which is a state agency. So they've reviewed all these perks, they've monitored them, and they've reviewed them on the sewage easement plats. So I have no doubt whatsoever that this is a very successful cluster superior design.
We know that this development had to get the perk tests in by July 2012. We also know that this area cannot support this amount of density and development. Now, because you are grandfathered from the provisions of SB 236, that means you're allowed to go forward with it. My concern is that we know that it's inappropriate there, And because we know it's inappropriate, and our zoning ordinance says that you have to further the goals, I think that's grounds to deny the application. And that's...
Mr. Chairman,
Yes.
there isn't even a motion on the floor to open up that discussion. So I apologize, but I'm reaching the point where I think Ms. Schertler is testifying and not asking a question.
Any more questions for Mr. Lessner?
Yes, please.
Go right ahead.
Okay. Mr. Lessner, last time we talked about the fertilizers and pesticides and herbicides and salts. And you addressed the issue of fertilizers. But I'm wondering how our road salts, it's summertime, we're not really thinking about snow removal, but what impact will those salts have in such a sensitive area? Can you address that? And how will they be removed safely?
Forgive me, I don't specifically remember that term being used. Perhaps it was. I did not address that. As you well know, I'm not going to be the one, nor are you, to address snow removal and salt applications. That would be a county performance. The Public Works Department would
Okay, it was mentioned. If you didn't remember it, you didn't remember it. But my greatest concern was the firearm use on the adjacent property, and your solution was to post every 100 feet a no hunting, no trespassing sign. Well, have you spoken to the adjacent owner to see what is actually happening on that property? And is there enough of a buffer zone? Because I know that munitions can probably travel about 100 feet per second. So is there enough protection in that area? Because to me, that really is it for me personally. That's a safety issue that bothers me. And it hasn't clearly been addressed, or at least not enough for me.
Well, I mean, it's a personal property rights issue. As we spoke about a few weeks ago, and I'll say it again now, if someone in that area or right down the street wants to hunt or shoot guns on their property, I don't believe there's any law against that. I will say that I believe there is some type of an ordinance or law that says that they cannot shoot within 450 yards, I believe it is, of a homestead or a business. So that being said, I mean, that would be one restriction. I personally have not spoken with the adjoining property owner regarding what he does on his property. I know you were concerned with the signs that he has posted out there. I don't really see that that's a problem. The folks that are going to move to this neighborhood, I'm surely imagine that they're going to drive down Adams Willett Road and Liverpool Point Road, and they'll recognize the fact that they're in a rural area where folks hunt, shoot, target practice. If there's any type of commercial activity that goes on there, it would need to be permitted. To my knowledge, there's currently not. So, if he wants to do any type of commercial shooting range, he would most likely have to come before the Board of Appeals for approval to do so.
I understand. But again, you haven't spoken to the adjacent property owner to be sure. And as I read the last time from our updated our zoning regulations, 4.02.290 on outdoor rifle and pistol ranges, it said that these uses are permitted in the AC, which we're talking about tonight, and that the adjacent areas shall be predominantly undeveloped or occupied by low-density land uses such as agriculture, etc. So if this property owner is in regulation now, my question then, and still is, what impact is providing a residential area how is that going to impact the adjacent
Well, I'm certainly
owner?
not the legal expert on guns, but we have a right to do on our property what the zoning code allows also. If you're talking about a commercial activity, it says that it's permitted, but if you look in the zoning chart of permissible uses, it probably says with a special exception or with conditions.
But we don't know that because there hasn't been a conversation. My concern is not that that the rights are being violated. It's just a safety issue. Is there enough buffer? Is a property owner going to impact another, and how? If the owner of the adjacent property is in compliance now, then the concern for me is what impact, because they're saying agricultural, low density, such as agriculture, but now you're placing residents in that area. And as I said before, when I visited the site, I could hear activity coming from the property, so I wasn't really sure what was going on, and that's why I left.
Okay, well, I gave you several examples of other subdivisions, and I would probably offer that I'm very familiar with all of them. And there's hunting activities that go on in the adjoining properties on just about all those neighborhoods. The personal property that I live on, there's a subdivision beside me, and we hunt on our property. So it's the same everywhere throughout the county. I certainly understand your concern. That's why I offered to do what we have done, just in case someone is on that property and moseys through the woods, walks through the woods while he's hunting. He will see a visual barrier, so to speak, of where the property line's at. So
there is a barrier?
Well, I'm saying we'll be putting up signs.
But that's not really a barrier. That's just a warning.
Well, we can paint the trees also. That's the common practice for landowners to delineate their property. You paint it with blue markings. You probably see it in the woods all the time.
I don't go in the woods.
Okay, well.
But, it's just, I just wish that there had been some sort of conversation to be sure of what's happening so that the potential residents in that area are not in harm's way. But to guess that they're not, to me, there just hasn't been enough done. And if a person is on the adjacent property, it may be closer than 100 feet, then that munition is going to be unforgivable. That's just my bottom line. So that gives me a lot of trouble when I think about this. That alone gives me a lot of trouble with this particular project.
Mr. Lesnar, owning property myself and hunting in terms of signs will deter people. However, if they encroach on private property, sometimes they're encroaching at their own risk, because we are surrounded by development and people are aware of signs that are up. And some people will put up signs, some people will not put up signs, and that's the choice that the landowner has. I mean, you can't force someone to do something if they don't want to do it, but I can understand what you're saying in terms of what you're proposing is fine and well, but some people do the best they can with what they have, and others...
Well, I think for our neighborhood, I'm doing what I can. We're going to put up signs wherever there's lots that butt up against the property or come close to the property as another deterrent. I will tell you that the property owner to the left, I have spoken with that fellow, and he knows what we're doing, and he's well aware, and I know for a fact he hunts on his property also.
And I understand about the signs and all that, Mr. Chairman, but what if it's a child? Children wander. I'm just saying, adults, we have the responsibility. I saw the signs on the adjacent property that said firearms in use, but I could also hear close shooting, and I could see through trees. So, I just don't know enough about the adjacent property. Is he or she in compliance, and is this property going to impact and force them out of compliance? I don't know. I don't have enough information.
I don't know either.
Thank you.
Anyone else? Joan?
No, I was just going to say in response to Ms. Sherrod's concern that being one that's lived in rural areas of Charles County all of my life, most properties, or many, do not have no hunting. There is hunting season. It's expected that this is going to be a decision of individual property owners as to whether they post or not. But that clearly is not a problem in Charles County in terms of anyone having gotten shot as a result of someone exercising their Second Amendment rights on their own property. And it's not something that we can just say or regulate individually. Many people don't put any no hunting signs. Some might, but it's an individual choice. It's not something the Planning Commission can regulate.
Any other comments from my colleagues? Thank you, Mr. Lesnar.
Thank you.